afternoon. As a lawyer, I was quite loud and I wouldn't need this. These 6-7 years of being a judge has, I think, mellowed me down, and now I need all these external gadgets to address you all. Why don't you come in the front? These are not reserved seats. Please come in the front. Okay? Be comfortable. All of you, please come down. Keep coming ahead. Please see younger people. It gives me a lot of excitement. When I see the seniors, it makes me nervous. Worries me a little bit. Did I prepare enough? Will I be speaking right? Will you all understand that I may falter when I deliver certain lectures, but these are human errors, so forgive me. Before I start delivering this lecture, I would want to communicate with you. I need to talk to you and you need to talk to me. How many of you have been practicing for just a year? Can you raise your hands? 1, 2, 3. Okay. 8, 9 of you. 2 years? Okay. 3 years? Above 5 years? Oh. Okay. So the first year law practitioners, why have you taken up the practice of law? Can you, one of you, tell me? Give them a mic, please. One of you, you need to speak. You're lawyers. You can sit down, be comfortable. This is not the courtroom. Yes?
So, Your Lordship, I have taken this practice as my profession because I think it's very interesting because it's not monotonous like other, I might say other fields. I feel that law practice is quite diverse in itself, and it gives me a lot of opportunity to learn and apply my expertise on the it is a practice where I also learn and in the process, and I also can apply it to my practice as a profession. So I've taken it as my profession.
Okay. Anybody else? Pass on the mic, please. Yeah, lots of you raising your hand. First year law practitioners. Somebody said no. Who's this lady who said no? I don't want to speak. You, the third from the left. You looking that side. You. Yes. I want you to speak. Nobody says no when I ask you to speak, okay? I'm still a judge. So, joking. Yes. Why did you take up the practice of law?
So, I want to know the law better, that's why.
You want to know law better?
Yes, sir. I want to help myself than other. That's why I want to. I want to know more. I want to.
Yes. That's an excellent thought. That's a lovely way of putting it. This desire to know is, I think, the most important aspect of law which will make you succeed. So it's a very good thought. The next one, you.
Your Lordship.
Say something different from what they said.
I feel like this is a noble profession, so that is why I have come to this practice field. So,
what is noble about this?
Everything.
So till now in this 1 year, what is this noble thing that you've done?
I've given justice. Not me, but my senior. I have helped my senior to
Yes, come on.
I helped my senior, Miss Zola Megi, to acquit the innocent person.
Okay.
That is
Innocent person.
Yes.
Are you sure?
Yes.
You are absolutely sure that your senior was representing an innocent person?
Yes.
Fantastic then. But your senior doesn't represent only innocent persons. She represents a lot of people who ought to be convicted. But they don't convict her because she's a good lawyer.
Yes. I want to be a good lawyer like her.
But would that be justice then?
Yes.
Why would it be justice when a person who ought to be in the gallows is not sent to the gallows because of Miss Zola Megi?
Because it is her talent.
But clap to her talent, but has justice be done? He's been left free. He is not guilty. He is guilty. But because of her talent, you've managed to take her out, or him out. So would that be justice? Keep that thought alive. Come the second year in the profession. You spent 1 year already and you're in the second year. What has changed in this 1 year in your thinking? When you started off the profession and now, how do you feel?
Your Lordship, I felt like my thought process has changed till now. Giving justice to the people of society and learning about it is one of the justice for myself. And for other people also, it is a justice because we are doing justice for ourselves and for our society and for our future betterment of our futures.
You're working with?
No, I'm independent, but I am working with Miss Zola Megi only.
Somehow I feel all of you are trained to speak like this. Come on. Somebody else? Yes.
The first year of practice was because, to be honest, because I did law. But the second year, I think I found my purpose. I enjoy doing what I do as a lawyer, as an advocate, because back of the mind, I always thought that I should be knowing the law, and to know the law, only then can I think of doing justice. Even if I am citing the wrong person, I think he has the right to be heard. So I'll at least give him I'll be his mouth over there, and I think I'll be doing this all the time as a profession at least.
Okay. Anybody in the 3 years practice, 4 years practice? Yes. You're very senior, but you can speak. You yes.
No, I'm only like 2 years, not 3-4 years.
Okay, 2 years. Okay. Very good. I see you so often in court that I think you've been there for a long time. That's good. Yes.
I started practice actually only in the whims and fancies of my parents. I actually wanted to like
all of us
pursue-
did that.
I wanted to pursue academics. I
Ah.
wanted to pursue, after my LLM, I wanted to do PhD.
You've done your LLM as well?
Yes,
Oh my
but-
God. You're more learned than me. Then?
Well, then after I started practicing, I got to understand that law is so much more than just reading in a room. Once you go out, once you sit in a court, once you interact with somebody far more intellectual than you, which happens so very often in the bar room, you get to know a different perspective. You understand that law is dynamic. It's always changing. You engage, you get to learn more. And then you help other people by becoming their voice. You learn just not writing but drafting, which are two different things. There are things which are better said and done once I started to actually come out and practice. That is what I want to achieve and learn more in my upcoming years.
For 2 years of practice, I think this is amazing. You should be here. I should be sitting there. Very good thought. Yes. You've been there for a long time. Fairly long time, isn't it? I'll ask you a different question. What is the difficulty that you face in your practice? And now since we are, I think today, going to deliberate on criminal law, focus on that. What is that troubles you? What is it that, where you think, I need to know more? Which area?
Mainly with regard to practice, I've been practicing for more than 5 years. So right now I'm stationed at Mangan District Court.
I'm fully aware of all that. Don't give me your introduction. Yes, tell me.
Lordship, what I'm facing difficulty right now is mainly with regard to the evidence part. Mainly in criminal cases like documentary evidence, when how to prove it. I will place all the documents before the court during the trial, but how to prove it, that is very difficult. And one more thing is that recently we are getting difficulty with the thing that 164 statement of the victims that is placed before the court, and when the victims come and depose that I know that that is my 164 statement I have given before the magistrate, and that is my thumb impression and all. And later, if I don't cross-examination or cross-examine or go through that 164 statement read over to the victim, if suppose in 164 there is a grave allegation against the accused person, then I won't read that statement totally because it comes after me, it's going after me. So I won't read that, but the victim is accepting that that is 164 statement. So when the argument comes, then the judges will tell us that you didn't take this point in the evidence, didn't take this point during evidence, and you didn't brought that contents were known to the victims. So in that particular time, I get a difficulty in contradicting also. Like ma'am will say that you haven't gone through that content of the 164 statement, so how can you contradict this with the evidence before the court? So that is the main difficulty I'm facing, Your Lordship.
Oh, since you know it is not difficult at all. But anyway, we'll talk about it, deliberate more. But I'm worried about the boys. Except for one, there is nobody speaking. Give the phone, the mic behind. Yes.
My Lord.
Yes, sir.
My Lord, it's been 3 years as an advocate, and
It's already been 3 years.
It's been 3 years, my Lord. So now I'm doing it independently. But my Lord, what I learned.
You're independent in 3 years.
Yes, my Lord.
Wow.
My Lord, what I learned in these 3 years is I was working under Mr. Jorge Namkar, my Lord. So in this profession, what we get is a sense of responsibility. Like for example, my senior, when the clients used to come and meet him, there was a ray of hope. So we are like a ray of hope for people, and this is a profession where we can actually help people to like being available for them in the right time. So my Lord, this is a profession where I learned that we are just a ray of hope for people.
So it's all very well to be the ray of hope, and it's all very well to have this desire to be, doing something that will really help the society and work towards the betterment of our society. These desires are, fantastic. I think it's laudable. It is, it needs to be recognized. It needs to be appreciated. But how do we get about it? Do you think 3 years is good enough to be independent? What you said just now?
My Lord, I am still at a learning stage. Every day is a learning stage.
So then how are you independent?
My Lord, for example, my Lord, like right now when I get my own case, like few cases obviously, 1 or 2, but when I am so much engrossed, now I understand how my senior remembers the page numbers. Now I know how he remembers the annexures, why he used to get the scolding when we didn't remember anything. So my Lord, a sense of responsibility.
But remembering page numbers, is that really it?
My Lord, the first step towards finding the right word, my Lord. To know your file, to know the file, to know the matter, to know the case. My Lord, that is the first step that we should be.
Okay. Behind. Yes?
Please, Your Lordship. Lordship, I have been in this profession for more than 10 years, my Lord.
That's right.
So, my Lord, criminal cases which I have done very less knowledge. So I feel that I should learn more. So therefore, I'm in this training today. And Evidence Act being one of the most important act in criminal or civil matters. So Malaj, I feel that despite being more than 10 years in this profession, I feel that I should...
Since you have not done criminal cases,
Please,
your confidence level is low.
Please, Your Lordship.
So what does that reflect, the younger ones? He's put in 10 years of practice and he thinks that he's not good enough and he needs to know more as far as criminal law is concerned because he has not practiced criminal law. What is the takeaway from that, the younger ones?
Your Lordship, like I mentioned, it is a continuous learning process, and also when we look into the litigation aspect, it's always better, like we have also been advised to start from the trial court itself. So the practice of law is quite different from the bookish knowledge that we have.
That's really not the focus that I want you to concentrate. What Mr. Sangye said is, I have put in 10 years. 10 years is a long time, isn't it? In 10 years, he still does not have the confidence to take on criminal cases because he doesn't know the understanding of how the criminal cases are maneuvered. So what is the takeaway from what Mr. Sangye said?
Your Lordship, for that I personally feel that it's very important to spend time in the court and also to observe other advocates, how they do the cross-examination.
Do you think Mr. Sangye is not spending enough time in court and therefore he lacks the confidence to do criminal cases?
So I don't know about how much time is he spending in the court, and with all due respect, that is my personal opinion that...
So if you spend more time in court and just watch others do it, criminal law, you think you will get enough experience to take on criminal cases and do it?
No, Your Lordship, we will get a lot of expertise, like we can get a lot of idea as to what are the questions that needs to be put to a particular kind of witness. However, we also need to master our own facts, like whatever is there in our particular case brief, because what I have felt is, although we see a lot of advocates doing the cases so well, but if we really want to do our case well, then we really need to master our facts and also the point of law that is there related with our case brief. So it's very important to take up cases as well, Your Lordship, because if we keep on being reluctant of taking a case, until and unless we take a case, we won't realize how to personally go and cross-examine a witness, or how to personally do be a part of a trial itself.
So let's just hypothetically, you have no criminal practice. You take on a criminal case, it's a murder case, right? You think you watched somebody perform and therefore you think you can take it on, and then you take it on and then you conduct the trial. In the end of the trial, the person gets convicted. Now what happens?
Your Lordship, reading is also very important.
No, you read, of course you will prepare, but he gets convicted. It so happens that he gets convicted. What happens to your mental state?
It's discouraging, Your Lordship, but there are certain cases where it is a conviction case. We know
No, I'm not talking about those cases in which he must be convicted. But it could be because of your lack of experience that you could not conduct the trial the way it should have been, and therefore it resulted in justice not being done because of your lack of experience in the trial. But it has already happened. The trial has been conducted, you have finished your work, the judge has rendered his or her judgment, and that's the end of it, conviction has happened. Now what happens to your mental state?
It's discouraging.
Do you think about it? Does it worry you?
Yes.
Does it bother you? But then does it mean that you don't take up these cases?
No, Your Lordship.
So this conflict, how do you resolve this conflict? I can understand what Mr. Sangye says, I can understand what you say, but then these are conflicts that are always ongoing in all our minds, isn't it? It worries us, it troubles us. So how do we do it? Do we say, no, this is my bread and butter, so I need to do it? What if he gets convicted? That's all right. I guess he needed to be convicted. I'm happy, it's fine, it's all right. Let's move on to the next case. Is that your attitude, or would you sit down and think about it? Would you then go through your file again and see, where did I go wrong? How did it happen? Did I falter anywhere? Does it bother you? Does it bother you that because of what you did, maybe somebody is in trouble? Or you think, no, he was a criminal in the beginning, he was an accused, now he's a convict. There's not much difference between A and a C, isn't it? Between A and C, there is a B, and there's a big but. How do we resolve these issues? It is time that you all think. It is time that you all worry. Because this worrying, this botheration, this trouble in your mind will make you what she says, do what she says. Seek knowledge. That's what you come here for. I don't know whether I can impart that knowledge to you, because every time you all come to my court and make a plea, I think I know it all. I give my prima facie opinion, and as it progresses, slowly I realize what I prima facie thought was wrong. I change my mind. Does it trouble me that as a judge and a judge of the High Court, I am sitting there in a high pedestal and giving an opinion right in the beginning saying Mr. Sanghi is wrong. And the end of it, I'm writing a judgment exactly what he is saying. Does it make me small? Does it worry me that I gave opinions without thinking? And what should I do then? Because I don't see any difference between what you all do in the courtroom and what I do as a judge in the courtroom. We're doing the same thing, isn't it? We are all helping the society get justice. And that's so very important. There's a triangle here. I'm sitting here, the plaintiff, the defendant, the prosecution, the prosecution, who's the other side? The defense. Somewhere I feel that this beautiful congregation that should be there in the justice administration system is not there. And that's where you need to think. The desire for knowledge is so important that if you do not have that desire, then you will do what you do because you have to do what you do. And nothing more than that. But when one of you, the youngest one of you, come and to my court and make a statement, sometime I may be dismissive. Most of the time I am. I'm sure all of you agree to that. The lawyer in me doesn't die. It comes out right in the beginning. When I do that, what is actually happening in your mind is that I've been told off. Sometimes it is very discouraging. For a weaker mind, it is troubling. You want to run away from the profession. I don't know. Should I be here? I mean, every time I speak, this judge comes and lambasts me, troubles me. He's always questioning. He's telling me I'm wrong. But that's the challenge you need to face. You need to be able to tell the judge that he is wrong. And how do you do that? How do you tell the judge you're wrong? Are you going to go and get up and say you're wrong and I'm right? So how do you do it? That's the craft you will have to learn. I'm sure, those of you who have practiced in my court, you will know what I'm saying, that in the initial stage, maybe I had an opinion much contrary to your opinion, but in the end, when I delivered a judgment, the opinion was completely. See, this process of churning that happens in the courtroom. Do I take the credit for it? No, I don't. When I write a good judgment, the credit goes to you. It is your mind that works with mine. It is that mind that troubles me. It is that mind that pushes me beyond the realms of all these letters that are around. Long time ago, when I was practicing in Delhi, my firm that I was working in told me that you should go and brief a very, very senior advocate. He's no longer there. God rest his soul in peace. At that time, he was a very senior advocate. I was this young lad from Sikkim just trying to open up to the huge Delhi legal fraternity. You're just a speck there. I worked hard. I really worked hard, and I read everything that was there in the brief. I underlined the most important portions. I flagged every page which I thought was important. I read every judgment which was there in the impugned judgment. I made my notes. I couldn't have gone wrong. I was absolutely confident to brief him. I went alone. And there he was in his chamber, sitting all alone, very elegant, very pronounced, in this beautiful green, rocking chair. And then he made me sit. I thanked him. So he says, go on. So I started. Non-stop. For good 35 minutes. And then went to 35 minutes, 45 minutes. I had so much knowledge, I thought. In the end of it, he looked at me and said, बेटा, जो आपने कहा, ये तो मैं भी पढ़ सकता हूँ. अब जो लिखा नहीं ये बताओ मुझे. I was totally lost after that. I didn't know anything beyond my brief. He says, this is a brief which you sent me 2 days ago. I've read everything. But tell me something more than that. I didn't have a word to say after that. He had read the judgments, he had read the brief, he knew it all. That thought still lingers 30 years down the line. That troubles me. Do I know enough? Does it bother you for not knowing enough? If it doesn't, it is time that it should bother you. It is only when it bothers you that the process of churning will start. And until this process of churning starts, it starts with a troubled mind. Most of you listen to songs, don't you? You listen to the reels also. You listen to poets. You listen to singers. The singers who have from the black community. They are, I think, fantastic singers, isn't it? They're fantastic. They're singers who, the moment you hear their voice, it touches your inner soul. It troubles you. It kindles all your little things that are hidden behind, inside you. Am I saying something which is alien? Does it happen to you? I'm sure it happens to all of you, isn't it? Now let's cut it there. Nursery rhymes. Look at the, have you thought about the nursery rhymes? Tell me one nursery rhyme which you know of. Humpty Dumpty. What happened to Humpty Dumpty? What happened to Humpty Dumpty? Tell me, what happened to Humpty Dumpty? That's right. Tell me a nursery rhyme where there is no pain. These songs, these writings, this poetry has come out from places where there is maximum pain. From the ghettos. Why? It is the troubled soul that has brought alive the you. And we dance in joy listening to these songs, isn't it? Most of your nursery rhymes comes from that age and time when there was troubled times. It was written by troubled people, parents, mother, father, didn't have enough food to give the children, and therefore they sang these poetry to nursery rhymes to keep the children alive. So what is the takeaway from here? Trouble your mind. Trouble yourself so much in law, since you are in it, that it gives you that joy. Because if you get that joy, it will give everybody around that joy. You must be wondering, I have come here to read about Evidence Act, understand Evidence Act. Maybe you would talk about section 65 and 35 and 14 and 16, but this man is not speaking anything about that. He's just talking from his hat. But I think it is important that we talk about it. We don't talk nowadays. You know, as a judge, I'm supposed to be aloof, so I'm aloof. I don't get to communicate with you. Right? And nobody communicates with me, so we don't talk to each other. When you don't talk to each other, we don't know what is happening with each other. So this triangle in an adversarial system of justice is disjoint as I see it. Each one acting on their own. We all talk about this link, this triangle is linked, it's supposed to be linked, isn't it? But where is the link? You don't talk to me, I don't talk to you. I don't know what's going on in your mind. I don't know what's happening in your lives. And nor do you. So where is this link? How do we revive this link? I have been in trouble for the last 6 years. This is my 7th year. For last 6 years, when I became a judge, the first year I took on the task of heading the Judicial Academy, I requested the director that substantial time shall be spent in imparting education to the lawyers. The feedback, however, was terrible. Nobody came. We organized everything. We thought we organized everything, but there was a trickle of lawyers who attended. Some of them who attended then are still attending. Panila? So the first year, this is in 2017, if I'm not mistaken, more than 15 sessions. Handful of lawyers. The second year, even less. The third year, lesser than that. I thought there's some lack of communication between the Judicial Academy and the lawyers. And maybe we need to do something right. So I requested the president of your bar, Mr. N. Rai. He became the president because you voted for him. I requested him, please take on the task of taking at least a lecture for your colleagues. He said yes. He came here. 6, 7 of you came. 2 rather. I think. That's right. So is there no desire for knowledge? I am so happy that you made this statement. What is happening? If you want to keep this link alive, if you really want to aid the administration of justice, keep this link alive. If this triangle breaks from any side, justice will not happen. Your people will not get justice. Believe you me. Do you think I sitting out there and writing in my hi-fi legal language judgments will render justice? I assure you it will not. If you do not work hard. So I want you to spread this word around. Don't tell your colleagues that I was angry. I am not angry. But I am deeply hurt. Because even after 7 years of practice, of being a judge, I don't feel that I am away from you. Each day when I sit in the courtroom, I think of each one of you. It worries me. It troubles me. If I am provoking you, if I show my anger to Mr. Sanghi, it is because I bother about them. If I troubled you, I trouble you to search your soul. And I'm sure most of the judges feel that way as well. Whether they're the civil judges or the High Court judges. It's just that we express ourselves differently. We are all here for a cause. So I am no greater person than you. You. When I read what is happening in the courtroom during trial, I see there is a need to have these exchanges. I know with my 3 decades of experience as a lawyer and a judge now, I know where it is going wrong. Do I have solution to each of this? No, I may not have. But we can communicate, we can talk, and we can resolve certain things. And how do you do that? By sharing our experiences, by sharing our knowledge. If you stop this communication, it will not happen. So I have taken this so much time not to talk about Evidence Act, not to talk about CRPC, not to talk about IPC, but what I feel internally, what has been troubling me all these years, so that it touches you somewhere. Make that time out, okay? Please make that time out. If somebody is organizing something for you, it means that they want to share. It should not be a pain. Excuses like, Judicial Academy is too far away. We cannot, I don't know, it's on a wrong time, it's on a working day. See, I had my cases, I finished it because I wanted to be here and communicate with you. I finished it. Yes, I took some time, I'm sorry for that, but I finished my cases, made sure that I am sharing my knowledge with you. I'm here, and I'm so happy to see so many of you here. Thank you so much. Now let's get into law, okay? What's the topic today? But then it can't be a lecture, okay? I've done my lecture bit. I have spoken my mind, and this is what I do. Now that I've spoken my mind, we will now discuss appreciation of evidence in criminal trials. What happens in a criminal trial? Can somebody who has done criminal trials tell me the steps that happens in a criminal trial? You.
First of all, in criminal trial, there will be a charge sheet has to be filed within 90 days. Thereafter, SR, service of report, has to be provided to the accused person. Thereafter, a framing of charge. Thereafter, after that, 313 statement. Examination of witnesses, prosecution witnesses, thereafter a judgment.
So this is broadly the steps in a criminal proceeding, isn't it? When does the criminal justice system start working? When does it start working? The registration of an FIR. What is the FIR? First information report. But can you say something more about the first information report besides the fact that it is a first information report? What is the first information report? If I write a letter to the police officer saying that Mr. Sanghi was walking in the streets when he was in the courtroom, when he ought to have been in the courtroom, would I be writing an FIR? So, what is an FIR then? Young ones. It is a complaint. So, I am making a complaint. I am complaining that Mr. Sanghi was walking in the MG mark when he ought to have been in the courtroom. It is a complaint. Would that be an FIR? Cognizable offence. So, what is a cognizable offence? Fundamental rights. Sorry? What is the opposite of cognizable offence? So what is non-cognizable offence?
Lordship, I think it's when the punishment entails less than 3 years or 2 years, I'm not so sure, but when the punishment is more than 3 years, then it automatically becomes a cognizable offence. But however, there are some certain environmental cases where punishment is for 7 years, but the courts have still deemed it to be non-cognizable. So there's still a matter of interpretation.
I'm a little worried when I ask somebody to speak because he gives me a lecture. And then I really can't say whether he's right or wrong because he knows so much. You know. So I would rather speak to you all.
Actually, there was a criminal trial going on for an environmental case. So there the question was that it's going on in West Bengal. There the punishment is 7 years. But it's still a non-cognizable offence because the courts have deemed it to be non-cognizable. So
which statute describes a cognizable offence or a non-cognizable offence? So do you have the CRPC with you? You have your mobiles? Take it out. Now take it out and let's deliberate on it. If one of you want, yeah, you can take this and share it. Give it back to me though. It's the property of the High Court.
The first schedule, classification of offences. In regard to offences...
Is it in the first schedule?
Yes, Your Honor.
It's not defined anywhere else?
No, it's defined in the definition.
The schedule is in the last. Why do you start from the back? Start from the front. Look at the definition process. That's where you ought to look for definitions.
Cognizable means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule, or under any other law, for the time being, enforce arrest without warrant.
Correct. So the key words is a police officer can arrest without warrant. That's when the criminal laws is activated, isn't it? Now what happens after the FIR is lodged of a cognizable offence? What happens?
Preliminary investigation is...
Who is to investigate?
The concerned officer.
The IO. Who is the IO? A police officer who has been given power to investigate the cognizable offence, right? So he investigates. What is the process of investigation? It's very important for you. You're not police officers, but it's equally important for you all to know what is the process of investigation. Can anybody tell me? How does an investigation happen? Communication. Sit down.
Chapter 5 of the SJA, it starts from section 1 to 4 to 1
Okay.
All the responsibilities, procedures are taken.
So what actually happens? And I don't understand these sections. I understand the process. So tell me, let's be human. When you talk about sections, I feel alien. So tell me what happens actually as a layperson. When a police officer takes on the case, what happens?
You start collecting evidence,
He visits the place of occurrence, he draws the map, he takes the 161 statements, the 161 statements of the witnesses, he collects all these samples, he sends those samples to the RFSL on time, and basically then starts preparing the charge sheet based on all the material that he's collected.
So what he does, as I understand, is that he investigates, he collects information, he collects a lot of information and then comes to a conclusion. What is that conclusion called? It's called a charge sheet. What is the charge sheet therefore? It is investigation. Of course it is an investigation. But what it is, what is it? It is evidence. It's not a charge. What is it?
The findings of his
You just gave me the answer right now. When I asked you, then you are troubled. You said the right thing. He investigates, he forms an opinion. That's the key word. It's an opinion of a police officer. Is that evidence? It is. Okay. Anybody else? Do you agree with it? You don't agree with him? Is it a girl versus boy? Why don't you agree with it?
It's not an evidence because it's just collecting the facts. So the evidence.
Can opinions, let's now try and solve this. Can opinions be evidence?
It cannot be.
It does not become evidence. Like even in forensic, when we go to the forensic experts, he is actually only giving an opinion.
So is that evidence?
Not conclusive, but definitely.
So where do you get the meaning of evidence? Indian Evidence Act. Where in Evidence Act? Section 3. Does anybody have Section 3 of the Evidence Act? Take it out, please. We have a lot to cover, so quickly. Please sit down. Sit down. Keep sitting down. I am the only one authorized to stand.
Evidence means and includes all the statements which the court permits or requires to be made before it by the witnesses. In relation to matters of fact under inquiry, such statements are called oral evidence. 2. All evidence including electronic records produced for the inspection of the court, such documents are called documentary evidence.
So what we understand with this definition of evidence?
Evidences has to be made by the witnesses. Before the court.
This is practical evidence thing that is coming out. You know, it's so important. If you don't have that practice, you will not be saying this. Okay? See the difference between the two of you. You just started out, right? Yes, please tell me.
When we read this evidence, definition of evidence, we can see two things. One is oral evidence and the other is documented. So if we see the oral evidence, it says the statements, all the statements, when the court permits or required by the court, that statement has to be made by the witnesses. It's called the oral evidence, and the documentation, it means including the electronic records. That is for the inspection of the court.
Okay. Now I ask you a question. We've heard the definition. There's a judge sitting here, right? A lawyer sitting here. One of us will be witnesses. Now, Ms. Panila makes a statement to me. I heard that Sange slapped Zola. Panila makes a statement to me that she heard Sange had slapped Zola, and the judge sitting here records that. Now let's go back to the definition of evidence. What does it say? What is oral evidence?
All the statements which the court permits,
She permitted.
requires to be made before it by witness.
She permitted it right now. So would that be evidence?
Has to be made by the witnesses.
No, the witness needed. Panila is a witness. She made a statement.
Yes, Your Honor. Judge can presume that anything can happen. If we say section 140, something like that. There is a provision regarding that if the court can presume.
No, this is presumption here. Panila came and told me, right, that Sange slapped Zola. Here's a presumption. It's a statement Panila has made. Told me. And the judge has allowed this statement.
Yes.
Would that be evidence?
Yes, it would be an evidence because it says means and includes.
So it amounts to evidence.
Yes, sir.
Any contrary view? Yeah. But the judge is allowed. Why are you undermining the role of a judge?
Unless and until it is corroborated through evidence.
We're not talking about corroboration. I mean, don't confuse us now with corroboration. There is a statement which has been made and the judge has allowed that statement. Would that be evidence? Yes. I am who's did I even tell you that this is gone. Did I even tell you that Parila is out of her mind? Then why are you even presuming this? She's absolutely sane. Look at her.
Consideration, taking into consideration that whether she is on soundness of mind or not.
No. You cannot. You're not authorized to go beyond the facts that I told you. These are the only facts available.
It's not in relation to matter of fact because it's her who has seen Sange with Jolamiki man, not you. So if Lordship goes before the court, it's a hearsay evidence. You've not seen the...
But she has allowed me to say this and she's recorded it. And the Evidence Act, Section C3 says that is oral evidence. Reverend Paulus. So I have come here not to resolve issues. I have come here to trouble you all, to make you think.
It would not be the statement which is given by the Leela would not become as an evidence because the matter is not under inquiry before you.
Who said it is not under inquiry? I did not say that. Why are you making all these presumptions? It is a matter under inquiry. I am not the owner, I am just a witness here. No, I am to ask the question. You have to resolve my issues. I am having trouble with the Evidence Act right now.
Lordship, my question is...
Sit down, yes, you speak. Give her the mic, please. Please sit down and talk. You are not allowed to speak otherwise. Yes? But I have not given you any more material than the material I gave you. Now why are you adding facts into it? I mean, you all are very creative. Each one of you is very creative. You are going beyond the facts. The only facts available is what I told you and nothing beyond that. The question is, some of you are saying that it is evidence, some of you are saying it is not evidence. I want to be a judge now and I want to know who is right and who is wrong. I am not finding the answer. So help me get the answer. You are presuming too many facts beyond the facts that I have told you. Has it troubled you enough? Okay. Keep that thoughts alive. Appreciation of evidence in criminal trials, oral evidence and its appreciation, documentary evidence and its appreciation. This is a one classical example I keep giving. I don't know, many of you who have interacted with me may have heard it. If I have repeated it often, then I'm sorry. I need to repeat it again. In a criminal case, what you see very often filed by the police officer is a map. How does the map look? Can you draw a picture of the map? You've all seen it, right? Just draw the picture. To think about it. All of you thought about it? Now one of you describe the map. You haven't spoken. Yes. How does the map look? Sketch of the road. Now imagine this. This is a sketch of the road. Then there are buildings. There are how many buildings there? Two buildings. One on the left side and one on the right side? Or both on the right side? Okay, fantastic. So road and two buildings on both sides. Then what else do you see? Trees. How many trees? Lots of trees. One big tree. Then? A well as well. Okay. All of you have to keep all this in mind. A pawn shop. Then? In our imagination, what is missing? The place of occurrence. How is that marked? PO with an X, is it? With an X. So now all of us have imagined this. How many of you, when you see this map, thought, who has drawn this map? You thought of it? Okay. Anybody else? You thought, was he a good artist or a bad artist? How did you think? Huh? Terrible artist? What else? Terrible sketch? Besides that, what other thoughts came to your head? Who drew this map? Who is the person who drew this map? Huh? Sorry? Investigate. Is there a presumption or you're not authorized to presume in law? It must be. You have to be sure. It is the IU. How do you say it is the IU? Because he submits it, you presume that it is he who has drawn it. Is that presumption correct? Would he be right in presuming that? I am trying to take out the criminal lawyer in you and diffusing the judgeship in me. Why are you even presuming this? Has anybody told you that the sketch of, what is it called? What is this called? This document? Sketch map. It's called a sketch map. It's got a heading on top called a sketch map. Rough sketch map. Rough sketch map of the place of occurrence. This is how it is described. Somewhere when you take up these cases, you are all presuming that it is done by the investigating officer because he's supposed to do that. It is his job to investigate. You say no.
But most of the cases I've seen, it is not done by the officer.
Okay, that's your experience. But isn't the investigation to be done by him? So then wouldn't it be wrong on your part to presume that he has done it?
No, my lords, he usually writes it down, prepared by.
Prepared by. So if somebody writes prepared by
Puts his sign on
and puts his signature there, would it then be right to presume that he has done it?
No, my lords, he'll come to the court and give depose before the court.
So he will come to the court and depose about the sketch map. And then would it be right to presume that he has done it? Take out the criminal lawyer in you, come on. Yes, you presume.
If you come and testify in the court, that
What is your job as a defense lawyer? You're not the prosecutor, are you? Okay. So what's your job? How do you question him there? What are the questions that will come to your head? Come quickly.
Did you visit the PO?
Did you visit the PO? Then he says yes. Obviously you will say yes. Then what's the next question?
what is the scale that you have used for the?
Sorry?
What is the scale that they have used for the sketch?
What is the scale for the... And what will the scale give you? Come on. Third question. Third question, come on. None of you are speaking out there. What's happened to you? None of you have taken criminal cases? Huh? Or are you just mesmerized by my presence? that you can't speak? Come on. Speak. We are interacting. What questions will come?
Description of the PO.
Description of the PO. Come on. After how many hours he visited? I'm a little worried with all your questions. Because I have not disclosed the plot. What is the plot? Was it a case of murder? Was it a case of rape? Was it a case of theft? Was it a case of robbery? How are you making these questions without knowing the plot? I mean, you're so quick in making these questions. How? Did I tell you what exactly was the plot? So then why are you making these questions?
We have that case in our head.
Generic question. What is a generic? This is a beautiful word. Panina, I mean, you know the English language much better than me. Tell me what is generic. I know, I'm too. I'm flabbergasted. Generic word. It's a generic question. What is a generic question? Can you explain this to me? Come on, what is generic question? General question. It's a general question, so therefore we can ask. Come on, make an attempt. So the first takeaway from what I discussed with you is the most vital part of the second part of our cross-examination. The most important thing that a lawyer, a defense lawyer must remember is what not to ask. If you do not know the plot, if you do not know the story, do not ask. When you start asking these questions, what are you doing? You're feeding evidence. Why? What did you read just now? Section 3? Anything the judge records is evidence. Now what do you do? Can you take a whitener and what do you do with what is recorded by the judge now? All these questions that all of you made right now, right? So enthusiastically, because I gave you a sketch map, is recorded by the judge. Now what do you do about this? Can you delete it? Can you go to the High Court and say, please have it deleted? Can the High Court delete it? Can the Supreme Court delete it? It is recorded. It is evidence. Whether the evidence will go to the left or go to the right, you don't know because you don't know the plot. Who are you defending? I do not know. You asked all these questions without knowing the plot. So shouldn't you be asking me when I give you this sketch, what is the plot? What happened? What is the crime? What am I to defend? How am I going to defend without knowing the plot? It was a trap. And that first lesson I learned when I went to brief a senior counsel, keep that in mind. What you read in the brief is not enough. You got to know more. And you got to know much more because you are the defense lawyer. The prosecution is not going to tell you all those happy stories in your favor. So how are you going to know the plot? How are you going to know the story? How do you do that? By asking, by what you said, wanting to know more. If you don't desire to know more, then you will ask questions. Yes, document is here. Come on, judge, please sit down and write. And my first question, what's your name? Second question, which class? Third question, was it important? Was it relevant? Now, as a young lawyer, as young lawyers, you will find, how many of you work along with the prosecution lawyers? You are the prosecutor. You are not the prosecutor. You are defense. Okay. Anybody working for the prosecutor? Were you raising your hand or just, okay. Nobody. Okay. So I can just talk about one side. You know, they are very good prosecutors. And when you see the prosecutor during the examination, you may get impressed. Being impressed and saying, wow, he's a good prosecutor is good enough. Don't follow his footsteps. Because if you follow, then the defense will crumble. The defense need to know much more than the brief. Much more than what has been stated in the documents. What are the documents that are before you? The 161 statements, the 164 statements, the documents, the documentary evidence, and the whole lot of papers that the prosecution files. Sometimes it doesn't make sense. Many a times when I did, most of the time when I did criminal cases, huge. There was one particular case which I did, when I asked for the documents from the prosecution, what I was given was 3 trunks of filings. I got lost in them. I didn't know where to start and where to end. And when I finished it, I didn't know what I was reading and what I had read. So how do you make sanity out of this insanity? You need to be coherent. You got to know the plot. So important to know the plot. Now, I think most of you realized after being embarrassed, you got to know the plot, right? So how do we know the plot? How do we examine the plot? The prosecution will bank on chaos. The more chaotic the charge sheet, the better for them. Because the defense will have no clue as to what they were talking about. What they were talking about is known to them. It is not in the documents. It is in the document, but it's strewn all over. One statement from one witness, another statement from another witness, the third statement from a document. And they have the power to lead more oral evidence, even if it is not in the list. So you don't know the plot. The plot can come later. How do you keep alert to all this? What is the one word that comes to your mind at this time? You must have coherence. Something must make sense, isn't it? Now, therefore, what you need to do when the charge sheet comes to you is read the charge sheet again and again. Don't say, see everything the prosecution sees the way they see it. You got to see it beyond that. How do you do that? Now, I have a key to it. Should I disclose my key? He's worked with me, so he knows. Parita, you should know also. What I do is make a list of dates. I hope you follow that. A list of dates is something which you prepare if you are appearing in the High Court in every matter. A synopsis is something that you prepare in every case in that matter. But I haven't read a beautiful synopsis. I haven't read a beautiful list of dates. It is done because it has to be done. And I'm sorry, I'm very blunt. And you can tell your seniors that the judge said this, and I will stand by it. What is a list of dates and what is a synopsis? It's very important for you. I will say it in front of the judge. So we'll take a break and then come back. Right? I have all the time in the world today. So we'll deliberate more and we'll talk more and see how we can learn more and by sharing knowledge. Okay? So let's go and have lunch. In or scattered? Okay. So where were we? Sketch map, was it? List of dates and synopsis on computer. So when you make this synopsis and list of dates, do you know the Constitution begins with the preamble. But how many of you knew that the preamble was drafted in the end? Do you realize that? The Constitution starts with a preamble. But the preamble was drafted in the end when the Constitution was completely framed. After that, the preamble was made. And then it comes in the front. That's exactly the significance of your list of dates and synopsis. You can't start with the list of dates. You got to know the entirety of the case, all the facts that are relevant, and then what you spell out in your synopsis is the gist of your submissions. And what is it, the moot point that you seek to raise? What is that question that you seek to raise? What is that troubles you? What is that significant thing? Now, in the list of dates, when you prepare the list of dates, what you would do, how do you start preparing the list of dates? We're talking about criminal law. When charge sheet has come, there's a confusion of thoughts. The charge sheet is speaking something, there are huge number of documents. The order of witnesses is 1, 2, 3, 4. But if you read 1, 2, 3, 4, seldom will you have any coherence. The charge sheet is actually telling you a human story, isn't it? It's a story. Now, as children, we all heard stories from our parents, didn't we? And we got engrossed with that story. It was so beautiful, isn't it? It's the little stories that we heard from our parents. It was so engrossing. Why was it so engrossing? Because you're completely into it, isn't it? Now, that is what it is. It's a human story. Now, how do you explain this human story? What happens is we get bogged down. Because when you come into the profession, you see these great lawyers, Mr. Jorge Namka, Mr. So-and-so, so-and-so, and then you see them tall figures. And then you get little troubled. You feel like emulating them, you feel like following them. You don't know how to get about it. And that troubles you. And when that troubles you, you really aren't focused. What you need to do is focus yourself. You need to focus on the human story because that's what you all said right now. You came to help those who need help. They don't talk about great law concepts and ideas and section so and so and section so and so. Do they tell you all that? They don't. They tell you a story. It's a human story. This is what happened. Now, when the charge sheet is filed by the prosecution, I'm presuming all of you are on the defense. So we'll do the reverse also a little later. But as a defense, there is a human story. You are defending a person who is accused of a crime. He's not a convict. He's accused of a crime. Do you have this conflict? Do your people around you say, how can you take up this case of this particular person who is alleged to have committed such a gruesome killing? I mean, in Sikkim, unfortunate it is, but there are so many POCSO cases. It's troubling. I am sure your family members, when you are senior, when you take up these POCSO cases, are troubled. They worry, how can you take up these cases? Has this conflict been in your head? So how have you resolved this conflict? How do you resolve this conflict? Why are you defending a person who is being accused of such a terrible crime? Why have you taken up these cases? How have you resolved it? Can you tell me? Because your senior has taken it? Why? Of course. Whenever this thing troubles you, think of the triangle in an adversarial system. Right? There is a judge who is to render justice. Right? There is the defense and there is this prosecution. You are part, the problem is, as defense lawyers, we feel we are not part of the system. This is a sense of belonging has to come to you. You need to own the profession. Take ownership. Be proud of this profession. You're part of the administration of justice. Just as the prosecution must do the best to ensure that justice happens, you need to ensure that justice happens. Now look at that. Justice for the prosecution and justice for the defense. But the commonality is justice, isn't it? That's the common factor here. So we are all working towards justice. And so when we take up these cases, don't get bogged down with the grief. Don't get troubled with looking at things which are new to you. You've never seen a final report. You know, when you see that form on top and you see all these big things written out there, it may just bother you so much and may trouble you so much that I do not know. How don't you know? You've heard these stories all the time. It's human stories. Even when you are not a lawyer, you read it in the papers. It troubled you. It troubles you now also. When your parents told you, it troubled you. It troubles you now also. As friends, when you discussed it, it troubled you. It troubles you now also. There's no change. It's a human story. Human story must touch you. But when touching you is not enough. Now you are part of a professional system. You are operating as a system now. So how do we work towards this? When the charge sheet comes, first thing you do is understand the human story. Once you understand the human story, collate these documents. If it's a documentary evidence, it will have an order. It will have dates, right? Put these documents on a date-wise sequence. Okay? Put these documents in a date-wise sequence. So you've read it before, the charge sheet, as the prosecution has placed it. Now take these documents out, make a photocopy, spend a little money. Now put it in a date-wise sequence. And then start preparing a list of dates. Now how do you put a list of dates to a sequence of events which comes from 161 statement, 164 statement, documentary evidence? On the back of your mind is the story. You know the plot, right? As expressed by the prosecution in the charge sheet. So rough, like a rough sketch map, you have a rough plot. You have also, by then, deliberated, talked, discussed with your client. And that's vital. You need to probe. You need to know more. You cannot know from documents. What I told you about my brief when I went to the senior counsel, what I didn't know is that human story. How will that human story come to you? By your interaction with your client. Sit down with him. As lawyers, even now, I suffer that problem. I love to hear my own voice. I love to hear my own voice. I love to talk. So when a client comes, I allow him to talk for a while, and then I know the law so much that I pour all the law to him. You are wrong here, you shouldn't have done this, you should have done this, this is how you should have done. And then I hear so much of it myself, I create a story which is not the human story. I speak through experience. I've done it. All the wrongs that I'm trying to tell you is not because I was a great lawyer and now I'm a great judge. No. I have faltered. I have fallen down. I have made mistakes. I have done exactly what I am telling you not to do. I have talked too much. I have expressed my superiority in knowing the law so much to my client that somewhere facts have gone into the mist. कथा आ रहा है facts का सत्य नहीं आ रहा है. Where is the truth? And then we talk about truth, don't we? We all talk about truth. We are all here to seek the truth. But where is the truth? When you are not willing to listen. Where is the truth then? Somebody who doesn't know the law is accused of a crime. He's come to you to seek help. Somebody has advised him that he is a good orator. One of our great habits as a lawyer is we ensure that client is sitting behind. And when we argue, we keep on looking at the client. To ensure that the client knows that you are speaking for him. It doesn't matter what you are speaking. What is important is the client should know that you are speaking. He doesn't even understand English, you are communicating in English. He doesn't know. And you've said what you have to say. Is there a truth there? Are you really seeking the truth? Where is this search for truth? कहाँबाट पाउनुहुन्छ सत्य? त्यो सत्यको खोज हो नि त. त्यो सत्यको खोज कसरी तपाईले निचोड्नुहुन्छ? आफ्नो ज्ञान मात्रै बाटेर सत्य त पाउँदैन. है सुन्ने क्षमता पनि हुनु पर्यो. You must have that to listen. So spend time with your client, listen to them, listen to the human story. Now put that in your head. Okay? Look at the charge sheet, look at those documents. Suddenly you will see these documents alive. You will see the 161 statements alive. You will see the 164 statements alive. You will read between what is not said. Sometimes when a person gives a statement these are experiences, okay? A lay person gives a 161 statement. He doesn't know, she doesn't know what he is supposed to speak and what he is not supposed to speak. So in a case of attempt to rape, the witness will talk about what she ate, what clothes she was wearing the day before, what she had done, all that. Again, the truth gets mystified. But if you know that human story from your client by listening to them diligently, offering your ears to him, not your soul right now, but at least your ears. If you offer that, then what happens? You know that story. Now collate and put these documents in order in a date-wise chronological order. Okay? Compile it together and then start preparing your list of dates. Your clients will give you a lot of irrelevant things, but you know what is the story now. So you will weed out the irrelevant and then the relevant will come in. And then when you reread your list of dates along with your documents, that story will come out. That story, when you present it to the court will understand it. Because they are human beings. I don't look alien to you, do I? I'm not from outer space, right? I may not know a lot of things, right? But I attempt to be human. I attempt to ensure that justice is done for all of you. That's that commonality between all of us. We're all here to do justice, isn't it? Now, if we have that passion to do that, and if you collate these documents, your now list of dates will tell a story. It will not just be a list of dates because the High Court PP rule says there must be a list of dates. Now you put your soul in it. You have told the story which your client has told you. Now you collated all these documents, right? But you don't get the right to speak, isn't it? You don't get the right to speak because you are the defense lawyer. You've collated all these documents. You ask yourself, why am I doing all this? More prosecution, bhako charge sheet file the document list of dates, synopsis, you sabai बनाएर चाहिँ के चाहिँ गर्नु के भनेको यो सरले हैन? When you know this story yourself, you have had a long session with your clients. You've put all the documents together. You've read the 161 statement. You've read the 164 statements. Then there are little things which you will not understand. You will find gaps. This is the art as a lawyer, to find these gaps. And when you find these gaps, if you know the human story, finding these gaps is not an issue at all. You will find these gaps. कथा भन्दाखेरि यहाँदेखि त्यहाँसम्म हिँडेको कुरा गर्दाखेरि यो बाटोको कुरै छैन भने त कथा त इन्कम्प्लिट भयो नि त हैन? अन्त यो चाहिँ यहाँ चाहिँ के भयो भन्ने हाम्रो एउटा चाहना हुन्छ. We will have to be curious. We will have to know what happened between this and this. So you will ask these questions. And if you don't find answers, you will search. And what she said rightly, when you search for that knowledge you will gain. That is the role of a defense lawyer. To bridge this gap. Now, if you bridge the gap, the story is complete, the crime is done. What's my role? You help the prosecution. No. You see, crimes are committed in different circumstances. What the prosecution alleged as murder may not be a murder. It could be a case of private defense. It could be a case of culpable homicide not amounting to murder. What was alleged to be a case of theft may not be a theft. It could have been an innocent person seeing something, not realizing, and picking it up and taking it. Without any men's fear, without any intention. That's the human story you need to know as defense lawyers. But then if you do not ask, if you are not curious, if you do not read between the lines, if you do not try to fill in the gaps, you will never know this human story. You will always feel that the story the prosecution projects is the correct story. It may not be always so. Then, if you know that human story, and if you have helped your client get over the accusation of murder and brought it down to even culpable homicide not amounting to murder or private defense, don't you think you have served your client well? And then you will have lawyers who will say, this is evidence, okay, let's do something. When nobody is looking, we'll tear it and throw it. You will find lawyers who will do that as well. Are you really helping in the administration of justice if you do that? There's one document out here which actually establishes the entire case of the prosecution. The prosecution is not looking at it. The I was a good friend of mine. I will just take it and tear it. Nobody will even know. Judges don't have the time. If somebody is doing that, how would you react to it? Do you think you will help in the administration of justice when you do that? Stay away from that because that's a criminal offense. This temptation will come in your career. Be aware. It's an easy way out. I have this thing to win a case. I want to win this case. And this one document is the ruining factor. Let's destroy it. That's where your conscience must hit you hard. Are you therefore really helping in the administration of justice? All these things that you said as young lawyers, it's a noble profession. I want to serve our people. I want to do justice. I need to seek truth. All that will go like this. Good. If you can do it, and if you don't have a conscience, you're not fit to be a lawyer. This profession has a much higher calling. There are sacrifices which you have to make. I was talking to the senior members of the bar, and they are still telling me that it is still difficult for them. It is a difficult. In Sikkim, it's even more difficult. But suffer that difficulty. In the end of the day, when you go back home and take your pillow, cover yourself and sleep, that sleep which you will get in the night will be a beautiful sleep. You will dream well. The sleep will be sound. It will not trouble you. But if you have done this once, torn it and thrown it, believe you me, your conscience is going to prick you so hard for the rest of your life. Your sanity will be at stake. So stay away from that, right? Now when you collate and get this human story, how will it help you? How will it help you? When you are now going in for trial, you are fully equipped with the facts. But is that good enough? You got to know the law as well. So how do we know the law? By By reading it, of course. Right? But would reading it give us the law and make us understand how the law operates? Let us take a case of murder. Could you provision for murder? You're going to say something, but you'll restrain yourself. 300. That's right. We all know. Isn't it 300? Now what does 300 say? Why is it murder? What are the ingredients of the murder? Every offense must have certain vital ingredients. Learn about them, study about them, right? And then find out in that human story, are these ingredients there? If one of the ingredients is missing, then it may not amount to murder. If motive is not there, if intention is not there, it may not amount to murder. Right? If it is a case of private defense, it may not amount to murder. So if you know the law, if you know the ingredients of the law, then when you go for trial, when the witness is in the witness box, you are much more aware of what is happening around you. You are not just questioning because you need to question as a defense lawyer. You're not looking at a rough sketch map and throwing questions like you did a while ago. You now know the human story. Is it important for you to ask that question? And what is it that you will get by asking this question? Take for example, you are taking a case for a person who is something to do with, the allegation is about the age of the person. There's some dispute with regard to that. And the first question is, what's your name? What's your age? So you've done what the prosecution did not do it. I have seen trials and trials which come to me and I question myself as to what is happening in the trial courts. Why this question is being asked? And the only answer I get is, you are actually engrossed, so engrossed, looking at the great public prosecutors putting these questions, you think these are the right questions, and then you ask these questions. But you are not asking yourself, is this question really helping me? Am I going to get the right answer? When you cross-examine a person, the first thing, as I told you, is I'm putting everything together, So the first thing that you really need to know is what not to ask. But what not to ask is something which you will know only when you know the story, the plot. Right? Otherwise, it's just random questions. Because I'm embarrassed. At your age, that's what would happen. अब मलाई त देखो छ मेरोमा ब्रिफ आएको छ मैले क्वेशन गरेन भने त जजले पनि के सोच्ला मेरो क्लाइन्टले झन् के सोच्ला हैन अन्त त्यो अप्ठ्यारोपनबाट निस्किनुको लागि दुईटा क्वेशन त सोध्दै हाल्छु त्यो पहिलाको केसमा पनि उसले सोध्दै थियो यही सोचौँ न यही सोध्दिउँ न हैन त्यहाँदेखि सेकेन्ड क्वेशन सोध्दाखेरि धक्क टाउकोमा आइहाल्यो यो पनि सोधिहाल्छु एउटा कुरा भने यसको पनि सोधिहाल्छु अन्त एउटादेखि दुईटा दुईटादेखि चारवटा चारवटादेखि पाँचवटा 10वटा क्वेसन सोधिसक्नु तपाईँहरूले तर त्यो क्वेसनको बारेमा पहिला सोच्नु भएन आइ एम नट सेइङ यु डुइङ इट सोच्नु भएन भने त्यहाँदेखि के हुन्छ आउटकम चाहिँ के हो त्यसको व्हाट ह्यापन्स देयर आफ्टर इफ यु रिड So story is going somewhere else. Right? So what not to ask and what should you ask them? You should ask the question for which you know the answer. And that is the answer you're going to get from your client. How do you know that? How can I predict what this man is going to say? That's a question that will come to your head, isn't it? I remember a long time ago, and I keep giving this example. Sorry if I'm repeating it, but long time ago, I was doing work of a defense. And as I said, I got this huge trunk of documents. I looked at these documents, how I studied that document. Just for an example, so that you will take away something. Entire case was based on documentary evidence. But it was on file notes of different officers at different points of time, spanning over 30 years. You know how file notes are made in a government file. It goes from one to the other, from the junior most to the At every level there is different handwriting, different signatures. I sat down for months together with officers to find out whose handwriting was that particular handwriting. Along with the file notes, in my photocopy I made my remarks. This handwriting and this signature belongs to so and so. At that relevant time, this was the officer who made this. So my file became that much thicker. My computer, I had a very old computer. My mother had so generously donated some 32,000 rupees when I was a lawyer in Delhi, and I had brought it back to Gangtok when I started my practice here. It hardly had, I don't know how much. I know now you talk about TBs and all that, but it may not have some few MBs there. When I finished studying that case and making my notes, there was no space left in my computer. It was that old grey computer with this big box, and that box was full with that information. So I made these notes, and when the witnesses came, when I asked the question, 3 or 4 questions. The first question I asked is, he had given an opinion which was against my client. Okay? So I asked him whether he stood by his opinion. He was a proud officer. He says, yes, I stood by that opinion of his. So I had it recorded. The second question is, that opinion was expressed in his handwriting. Is this your handwriting? He said, yes, this is my handwriting, and that's my opinion. So I had it recorded. The second question is, I turned to the relevant page and I said, is this your handwriting and signature? He says, yes, this is also my handwriting and signature. Then I said, please read it to the court as to what you've expressed there. And he read it to the court. And obviously after that, his face fell, because he had given a contrary opinion before that. So when I asked these questions, I knew exactly what the answers are going to be. I put the question in such a way that he could not have said anything else. Could he have said, this is not my handwriting? And had he now seen that the earlier handwriting was his, he could not have said, this handwriting is not his. But when I asked him about the handwriting, I didn't even draw attention to the contents of that document. It is only when he admitted his signature and his writing, then I asked the third question, now tell me about the opinion. And then he read the opinion and realized that he had given a contrary opinion. By that, I had in my cross-examination with 3 questions completely demolished the case. So when you ask these questions, what is the takeaway from what I did? Firstly, study. Work hard. Make sure your computer is full. Your laptops are completely filled with information, with your study, with your notes, with your writings, with your thoughts. And when all that information is, you cannot go wrong. Then you are on top of the game. You know exactly what is it that you need to take up. So you don't have to ask random questions. अब कस्तो छ र? कहाँ जन्मिनु भएको? कहाँ पढ्नु भएको? Are these relevant questions? How does it matter where you studied? कस्तो छोरा? How does it matter? With these three questions, my job is done. You move on. So, it's not about showing off. It's about telling you exactly how it should be done. Okay? When you do that, then before you do that, when a list of witnesses are produced before you in the chart sheet, you're not looking at names. You are looking at witnesses who have expressed certain opinions, have made some statements. Find out what are those statements. It could be in the 161 statement, or it could be in the 164 statement. Then understand why this witness has been brought. If the witness has been brought by the prosecution to establish B, then you're asking on question on issue B is not relevant at all. Right? You need to focus there. Why was the witness brought? Why is the witness in the list? That's the first question that you... Then the second question, since you know the story, the second question is whether this witness would be helpful for your purpose to establish your story. Because you heard their story from your clients. You know that story. And you know exactly what is the role of this witness. Most of the cases that you deal with have rural settings. Isn't it? Most of 90% of the cases have rural settings. These are things happening in rural areas. So it is happening in a particular village. Few houses there, mati ghar, tollo ghar, right? Kaka, mama, bhanja, sabai त्यही त setting हुन्छ. हरेक केसमा त्यस्तै हुन्छ हैन त. So now you know that this witness may know little more than what he has said in, because in the 161 statement, the 164 statement, right? The prosecution is giving their story. But these people belong to a setting. It's a human story. That's why I keep repeating this human story. It's in a setting. यहाँ भित्र हामी गफ गर्दैछौँ, हामी कुरा गर्दैछौँ, हामी यति त छौँ यहाँ भित्र, है? When I know you are there, right? I know exactly what you've heard, what you've expressed, how you've thought, right? Now, when I go back home and tell a story to my family members, I'll talk about each one of you. I'll tell exactly how you expressed yourself. I know this story. It's happened in front of you. So therefore, when these witnesses are brought, they also know the story. It's just that they've expressed it in a different way. Can you take advantage of the presence of that witness and bring out your story? When I see this, there is the writer. Attempt गर्छु, do you story निकाल्ने try गर्छु, try fail भयो भने त गयो फेरि. There is no reversal. The judge is not going to scratch it out. So when you ask that question, be sure that the answer that you're going to get is the answer that you desire. If you do not have that confidence, then please don't refrain from making these adventurous attempts. So when you do this over the trial, when you know exactly why a particular witness is coming for what purpose, then you will know exactly how to deal with each one of them. And you would have served your client well. But in this process of trial, in a criminal trial, there will be issues of documentary and oral evidence, and that's what we are talking about, isn't it? Now let's talk about a documentary evidence. Let's go back to that same story which we talked about, and some of you were embarrassed about the questions that you asked. That is, what? In that little story you told me, and that imagination you imagined of the sketch map, what you ignored was the place of occurrence. But somebody specified there is a place of occurrence as well. Now I want to extract the lawyer in you. In all these drawings of the road, of the buildings, on the left hand side and the right hand, and the trees and the well, and the X place of occurrence, what do you see the difference? What is the difference in this sketch? What is that thing which is distinct, which hits you? Sorry? Of course it's a rough sketch, but besides rough, besides that, what is this that you see? You would see it like me, you know. Maybe I read a lot of detective novels when I was young, so I become the detective. I become the investigating officer. When I start reading charge sheet, I become the investigating officer. This is my habit, right? Because maybe I have read too many detective novels. But if you do that, for a moment, just think that you are imagining you are me and you are the detective, and then you are the investigating officer and you are investigating the case. And somebody has lodged the FIR, which is the first information report, which is not a summary of everything, but a gist of what crime that may have occurred. And then you take up that assignment as an investigating officer, you go there and investigate. I am the investigating officer. I am going to the place of occurrence. I am going there, I see that road, I walk on that road. I see the building on the right, I see the building on the left, I see the trees around, I go and see the well as well. I see it with my own eyes. Not where has the crime been committed? I don't see the place of crime, the PO. How do I see it? The crime has happened 3 days before, a month before. So how do I see that place of occurrence? Did you think about it? How did I see the place of occurrence? Sorry? When I went there, the crime is already over. It's gone, the body is gone, everything is gone. Or maybe the body is there. But how do I know that this is the place of occurrence? Witnesses. So when a witness comes in, what happens? Is it a first-hand knowledge? If a witness is telling the IO and IO is drawing that sketch map, go back to that imagining, all of you, imagine that sketch map again with the place of occurrence which you mentioned out there. Everything that is drawn out there, the road, the well, the trees, the buildings, are those which have been seen by the investigating officer. First-hand knowledge, as he visited the place of occurrence. But that place of occurrence, that the crime happened here, has been told to him by the witness. What is that called? What did we discuss about? Me telling the court that The court that, what was that story we talked about? Who slapped whom? Yes. What was that? What? Hearsay evidence. But in that sketch map, there is a hearsay evidence. It seems that place of occurrence mark X is a hearsay evidence, isn't it? Did you think of it? Did it bother you when you saw the sketch map, when you saw it the first time? Did it occur to you that this is hearsay evidence? One person is shaking her head. I'm asking the rest of you. He did. Okay, I'll ask you later how you did and what did you do thereafter. But why didn't it occur to the rest of you when you saw the sketch map? It is because you did not become the detective that I become. Put yourself in that position. You need to be the detective, you got to be the investigating officer. Put yourself in those shoes. Travel with him. The map take that really imagination तपाईको आउनु पर्छ. क्राइम त 3 दिन अगाडि भएको. You need to be curious. कसरी भयो त? कसरी जानकारी पायो त? कसरी यो इन्फर्मेसन पायो त? Now, as a defense lawyer, right, you will find that the investigating officer will always produce the sketch map and exhibit it. How many times have you seen yourself or your seniors objecting to the exhibition of this document? Because it has hearsay evidence. You all admit and agree there is hearsay evidence there? Have we objected to? Why? First time when I made a statement to the judge about a crime being committed, did anybody object to this? All imagine along with her, isn't it? So beautiful the way it is described. It's still clear in my head. But that's what you all are doing. You are capable of doing that. You can imagine. You can see things. Then make that extra effort. Travel along with the investigating officer. And see, you will realize these little things. These are great legal issues. I learned it much later in life. When a great luminary told me about it. It looks like the wise old man is speaking here, but that wise old man became wise much later because some other wise man told me this. And I'm boasting about it to you as if it is great knowledge. You see? And when that knowledge came to me, I asked myself this question, why am I not doing what I'm supposed to do? There is a human story which you need to know. At every level now, see, when the investigation happens, if you revisit and see what the investigating officer is doing, now what do you do with that? You see his story is coming in the charge sheet. Now, see the way he's seeing it. And when you see it the way he's seeing it, you will see these loopholes. He will not be able to bridge certain facts or there are gaps in between which he will not fulfill. Why is he unable to do that? There is no story there. The story must flow. Should be a story like your parents told you, like your brother told you, like your sister told you, like people close to you told you these stories and you're mesmerized with those stories. There was a flow in that story. When the story is interrupted with hiccups and gaps, there's something wrong, you must sense it. Feel that. And then investigate further. Revisit it as if it has happened. Kati picture हेर्नुहुन्छ? You like watching movies? What is the last movie that you watched? Any? I love Hindi movies. What in movie did you watch? You shook your head. You shook your head? Yes. You don't watch movies? How boring is that? How? Anybody watches movie? The trial. And that's so obvious. Criminal trials. Anything else? Who is watching movies? I mean, it's good, huh? Sorry? Oppenheimer. Okay. What else? I'm not into all this. Tell me. Animal, right? I've heard about that animal. That's also a human story. You will find people like that, isn't it? Now, when you watch these movies which you really like, don't you get mesmerized? Don't you get engrossed into this story? Right? Why do you do that? The narration is so good. The difference between a good movie and a bad movie is a bad movie doesn't have a narrative. You can't tell that story. But if you tell a story which is so good and so mesmerizing in the way it should be told, then all of you will be mesmerized. That's the story you need to know. Each case that you take up has a story. It should be as mesmerizing as an animal. You should be able to be engrossed and sit in your seat for 3.5 hours movie, was it? Or more than that? 3.5 hours. Most of the Hindi movies are now come down to 2 hours. The director made an attempt to do a 3.5 hours movie and he succeeded. He's a crosser. Each of the case must be an animal. It should take out that animal in you. And when you do that, you will know. Right? Now the question is evidence. What is documentary evidence then? In this whole thing. All of you have done your schooling, I'm sure. Class 10, then did your class 12, right? And then you did your, did any of you do your graduation and then do law, or all of you did? You did your graduation, all of you did the 5-year course, right? Now you have various certificates in your hand, including your birth certificate, right? When you asked for admission in your school, they asked for a birth certificate. Obviously to your parents, so you may have not given too much attention, but the parents were asked to bring the original of the birth certificate, right? And then when you went to your college, they asked you for your class 10 and for a class 10 because your birth is recorded there, your birth certificate as well as your class 12 certificate, because it records certain things. And then at one point of time you realize, oh my God, in my class 10 certificate, my name is spelled this way, but in my class 12 certificate, my name is spelled that way. And there is a mistake. And then you have run all over the country to rectify it. Many of you have done that. I have done it. And sometimes your age is written differently. But again you go back to change it. Why are these records important? And why is the college insisting on the original? You have produced the photocopy and they are insisting on the original. Why are they insisting on the original? Have you asked yourself this question? We do it mechanically, don't we? You exam ma bosnu parcha, original mangcha, gaera dekhaउँछ, photocopy dekhaउँछ, लिएर जान्छ. But have you asked, have you been curious? Why is it? Or you know it all. I'm sure you all know. Why is the original asked for? To authenticate. Why do you need to authenticate? Why can't they take your word for granted? This whole system operates on proof, evidence. And that's why Evidence Act is so important. Do you realize that? At every level of your life, you're dealing with evidence. You're dealing with primary evidence and secondary evidence. Without realizing it, now that you're lawyers, you know about primary evidence and secondary evidence, but as students, as people in the field of learning and educating yourself, you have always dealt with primary evidence and secondary evidence. And the authorities are always asking you to produce the original. And still I find in the trials that much of the trial happens in civil cases and in criminal cases with photocopies. Why is it happening? Doesn't it bother you? Because it bothered the authorities under whom you worked, educated yourself. All of you are graduates. All of you have done law. You've done your class 10 with distinction. You've done your class 12 with distinction. Some of you have been school captains. Some of you have been leaders in different fields. Right? And you've seen it all. As lawyers, why is it bothering you? When you are filing your cases and you are producing documents for examination for the court, why is it that it doesn't even occur to you that I am producing secondary evidence? And now, what is the relevance of a secondary evidence when primary evidence is available? Question to you. Correct. So there could be adverse things against you for that. But still we see a lot of documents which are just photocopies. Somewhere then, are we taking this job of ours as a job? This work of ours as just another work that we need to do? Or are we really engrossed in what we want to do? All these beautiful things that you all said. It's a noble profession. We want to do justice. We need to seek truth. Are we really doing it when you do this? We all knew it. We knew it when we were in school. We were told, we were told, bring the original. At one point of time, your teachers told you, isn't it? As students, aren't we curious? I'm sure you asked yourself this question. Why the original? As a rebellious student, you may have revolted. I showed the photocopy, but why is he asking for the original? Later on, when you realize that the relevance of it, you must have suppressed all your anger and realized that I was at fault at one point of time. But as lawyers, when you are doing it, is it pardonable then? Are we giving our full? It's all beautiful to talk about Evidence Act, Section 65, 113, 114G, but be engrossed with what you are doing, saving lives, getting justice. Everything will fall in place, believe you me. The Evidence Act will not look alien to you anymore. त्यो सेक्सन यसो पढ्दाखेरि त कोही बेला त कया हुन्छ कुन दिनमा यो प्रोफेसन लिएको जस्तो हुन्छ हैन मलाई त भएको थियो तपाईहरुलाई पनि हुन्छ होला जस्तो लाग्छ के काको गएकै छ एन्डै हुँदैन माथिबाट सुरु भयो तल बुझ्दा बुझ्दै अबुझ भएर गयो हैन हुन्छ नि त त्यस्तो अनि त्यसको सोल्युसन चाहिँ के हो सिम्पल कुरा हो नि ल इज लजिक होइन इट इज लजिक it is not alien to you. Stop treating law as something absolutely alien. भनेर डङ्गै लड्नु त भएन होइन we will have to resolve issues. You have now taken this noble profession. It's all very well to say it is. How do you deal with it? Right? So there is documentary evidence. So when I drill this into you, when you see the charge sheet for the first time, you realize one mistake that you have made. And all of you have made that. I'm going to give you a guarantee that you've made it. Under section 207 of the Code of Criminal Procedure, it is the duty of the court to give you the charge sheet along with all the documents. So when the charge sheet is filed, these documents are given to you. But it is given to you as photocopies. How many, truthfully tell me, have you taken the photocopy, asked for an inspection of the records and noted in your photocopies whether the originals have been filed in the court files? Don't you think it is important? Now that you know why your teachers asked you to produce the original of your class 10 mark sheet and your class 12 mark sheet and your birth certificate, teachers are always right when they teach you. These are lessons that we learn over the years. We don't give it much importance. That's a different thing, because you have so much of your teenage bubble in you that it doesn't matter what the teachers are saying. But they said it right. They told you the right thing. It's just that we didn't bother about it. Take a little time out and reflect in all these things that you learned in school. You learned in college. You learned in the process of going forward in life. When you enrolled as a lawyer, how many of you enrolled in Guwahati? All of you. How did you enroll yourself? How did you? You went there physically? Right? What did you go and give? Original copies. Why did you do that? Why were they demanding the original copies? Now, when there is so much of relevance to the original copies, when the charge sheet is filed with a whole lot of documents, none of you are bothered to ask the court, we would like to inspect the records and give us a date for it. I'm not making you small, I'm making you think. We all make mistakes. I didn't do it from when I started the practice. I didn't do it. It took me years and years to realize that this is what I ought to have been done. So don't be morally down, but learn now. Do an inspection. The moment you do an inspection, झन् छर्लङ्ग भएर जान्छ. के छर्लङ्ग भएर जान्छ? धेरै कुराहरू मूल कुराहरू हुन्छ. Very important things. If the case pertains to an age or a document which is forged, and if the original forged document is not in the record of the court, what is the implication thereof? How do you prove forgery without the original? Can you? Not as experts, I'm not asking you as experts. Will you be able to say from photocopy that it is forged? Yes, I can. Why can't you? What is forgery? Manufactured. Manufactured, we do a lot of this is also manufactured. What is forgery? What is forgery? Forgery is it a crime? Under the POCSO Act. What? Under? IPC. So what is forgery? Of course it's a criminal if it is IPC. But what is forgery? यो त फर्स्ट हो भनेर त कुरा भइरहन्छ नि त, गफमा पनि हुन्छ, गसिपमा पनि हुन्छ नि त, हैन? That's misleading somebody into believing what is not true, isn't it? So, can you find out whether it is a forged document by looking at the photocopy? Again, like you imagine the rough sketch map, imagine a forged document. And imagine your document to be forged. So let us now zero in into a document. Your class 12 certificate. Can you imagine this certificate? Have you all got it in your head? Your class 12 certificate. How can it be forged? Yeah, but then I can type it also. Would that be forgery? You have a printed certificate, I can type it in a piece of paper, exactly a copy of that. Would that be forgery? You are shaking your head both ways. You're shaking your head. Is it forgery? It's not forgery. Diverse opinions out here. Yes, the boys are absolutely silent. A typed copy would not be forgery. What do the boys say? No, but I'm giving an example now. You have a university, a class 12 certificate which is in print form. Somebody has typed it. Would that be forgery? Getting different ideas about forgery. If I was a criminal, then I will never. Fantastic ideas I would get to forge documents. So if I made a copy of exactly the original, would that be forgery? Okay, we are closer there. But then we are now going into another diverse concept in law. Let us stick to simple facts. You have a class 12 certificate. The question to you is, from a photocopy, can you or I find out whether it is forged or not? The original is not there. You didn't check. You didn't inspect the records. You don't know whether the original exists. You've seen a photocopy. There is an allegation of forgery. You are the defense lawyer. How are you going to compare it with the original? Yes, you're right. You have to compare with the original. State? You are the accused. Your client is the accused. You already know the truth. Check with the author of the document. So you will go to the university now. Okay. So very diverse ideas. But I was more in the criminal trial out here. That is further investigation. Good thought, keep it there. But what are we going to do now? the first thing which you need to do is inspect. Once a photocopy of the charge sheet is given to you, go to the court, request the court, I need to examine the original, and take your records and mark there. If records are not allowed to be taken, take a pencil and paper and write document 1, photocopy, document 2, original, document 3, and then go back and endorse that. Now you are equipped so much more to face your trial. If there is an allegation that you manufactured a document, right, and the manufactured document is not placed for the inspection of the court by the prosecution, what is the implication thereof? You got to study. I'm not going to give you answers. You're all expecting answers from with the look on your face. Think about it. What is an implication of an allegation of forgery, that your client has manufactured a document when that document which is supposed to have been manufactured is not placed in the original. Like you did not place the original of your class 10 and class 12 certificate before the authorities, and you were told to go back home and get it. What is the implication of a prosecution to that effect? You are not the prosecutor, you are the defense. I'm not asking for answers for the prosecutor. I'm talking about you as a defense lawyer. You are not the judge. That is for me to decide. I'm asking you, what is the implication? What do you think as a lawyer now? How do you react to this situation? Fantastic thought. I'm not talking about all these moral values. You are defense lawyer now. Weakness of the prosecution case. You know where they are weak. Now when you know where they are weak, question number 1. To the first witness who comes, who is dealing with this document. Question number 1. I'm asking, what is the question number 1? You are expecting me to put the question. Come on. Alright. You have now seen that the document alleged to have been manufactured and forged has not been placed in the original by the prosecution. And the witness who is to establish this document, the signatory of this document, is in the witness box. And you are the defense lawyer. What is the question that you're going to ask? This is not, you're making a statement. Is this the original? Can't you see it? This is where I'm asking you to think what not to ask. Yes. Now this will talk about document A and exhibit later. I'm not too happy with all this, but tell me, you will object. You will object. Why? You will try to produce the photocopy. Okay, so you will object. And what after the objection, the prosecution will still show it, and it will be marked as Ms. Zola says, marked as A and not an exhibit. and then the defense turn comes. Now you are on your legs. You're the defense lawyer. It is, I am not going to ask you about any other question pertaining to this document. What is the question that you're going to ask? The original is not in the case records. And what is the answer that you will get? Yes, the original is not in the case records. Would she be right in doing that? Come on. Sorry? Whether you call it alleged or not alleged, that document is there, isn't it? So, it really doesn't matter what adjective you use to describe that document. If it is in the original, it is in the original. If it is a photocopy, it's a photocopy, isn't it? Ms. Zola has already objected, saying it is a photocopy. Right? That's already on record. The question to you is, what is the relevant question? Is this your document? If you say, think so, he says, I am sure it is my document. Then what? If you're going to ask me that question, I'm going to say, I'm absolutely certain that this is my document. So that will be recorded by the judge. Do you think that answer which you got will help you? How will it help you? You are the defense. Then, if I was a witness, I would say that document got burnt in a fire 2 years ago in my house. Sorry? No, I don't have proof of it. The fact is that it did get burnt. I didn't report it to the police. You're absolutely right. But I didn't think, nobody advised me to report it to the police, and therefore I did not report it to the police. Yes, it is there. The document, the photocopy reflects all this. You are showing it to me, I will tell you exactly what it is. All this is being recorded by the judge. Remember, all these questions you are asking me, and I am the witness, is being recorded by the judge. Now let's read it. Question number 1. Do you think this is the origin? This is the real document? Answer is yes. Where is the original? It got burnt. Did you file an FIR? Do you have any proof? No, I don't have proof because I didn't think it was relevant to do so. Now what the answers that has been recorded by the judge is going to analyze it. The way I said it, she saw my demeanor. She noticed my demeanor. I seemed quite truthful. I immediately answered my question, your question. I didn't hesitate. I didn't fumble. She's thinking. What he says, what he said, may be the truth. There are cases when FIR isn't filed. Is it necessary? Is it compulsory in every fire there has to be an FIR? A tragedy has happened. My house is burnt. I am in grief. I don't know, not only my documents, I lost a lot of other things. The judge is thinking. She's a thinking judge. Maybe what Bhaskar said is right. Then you will be disbelieved. Your line of questioning, is it then helping you, your client, to come to the conclusion that your client is innocent? Think again with these 3 questions. Keep it in your mind Keep repeating these questions and ask yourself, did I put the right questions? Keep the facts in mind again. The original is not on record. The judge sees it. Judge has noticed it. The records cannot be manipulated after that. Only a photocopy is produced. The learned lawyer has already objected to it. And then there is a volley of questions by the learned defense lawyer, which gives me an opportunity to prove that what I am speaking is the truth, which actually may be false. Who bothers today about the oath that is taken in the courtroom? Tell me, anybody bothers? Yeso garyo kasam khayo. Who bothers? That's the truth, isn't it? सच्चाई यता पनि ढल्किरहेको छ, उता पनि ढल्किरहेको छ, ट्रुथ यता पनि गएको छ, उता पनि डिफेन्स लयरले जे भन्यो त्यही ट्रुथ भइगयो। गरे यस्तो भन्देऊ न भन्यो भने उनीहरु पनि हटाटटर हटाइहाल्छ हैन। This is what is happening in the courtrooms. ट्रुथ त हराएको छ। अन्त धेरै कुराहरुमा सत्य निकाल्नुको लागि थुप्रो क्वेशनहरु गर्नु पर्दैन। One thing that always bothers a lawyer is what my clients are going to say. They are watching me from behind. If I don't ask questions, maybe they think I'm not worth it. Maybe they'll change me as a lawyer. So will you do harakiri? What is harakiri? Suicide. It's so important to know what not to ask. Out of every 20 questions that have been asked by the defense, 19 are irrelevant. I'm sorry, I'm blunt. And the one question which is vital and important, which is there, suppose the prosecution case. Again, I'm very blunt, but this is what is happening in your courts. And then I ask myself, why is it happening? तपाईहरुले अलिकति कष्ट गर्नु पर्यो, पढ्नु पर्यो, प्रयास गर्नु पर्यो, दुःख गर्नु पर्यो, बुझ्नु पर्यो, यो अन्धकारबाट बाहिर निस्किनु पर्यो। धेरै उज्यालो छ बाहिर, तर कोशिश त गर्नु पर्यो त्यो उज्यालो देख्नुको लागि, हैन? कहिले त चस्मा लगाएर पनि देखिँदैन। Satya is such a beautiful word. We all love the word, isn't it? तर आजको संसारमा, as I see it, सत्यलाई खोज्नु साह्रो परिरहेको छ। न कोर्टहरुले खोज्नु सकेको छ, न लयर्सहरुले खोज्नु सकेको छ, प्रोसिक्युसन त टाढै जाओस्। सत्य खोज्नु नै सबभन्दा रेलेभेन्ट, सबभन्दा इम्पोर्टेन्ट तपाईको लयर जीवनमा। If there is anything that is relevant, it is this search for truth. and somewhere we are faltering. You all are very, very vibrant young minds. The way you have projected yourself today before me, I am extremely impressed. I see that glow in everyone's eyes. Labor hard. Work. Success is not going to come to you overnight. It is not going to happen, believe you me. Sometimes it takes a lifetime. Greatness, very few people achieve. Legend, only few become, isn't it? Should we stop giving? Any thought about it? Should we stop working towards it? Because I'm not going to be a legend. There's only one rock star. And there are thousands of musicians. Hundreds and millions. Isn't it? Should we give up? There is one Rap Chatmerali. And there are thousands of Bhaskars just all over the country. Should I give up? Should I have given up? Should you give up? पस्नुभयो तपाईहरु त अब यु आर इन इट घुसिसक्नु भएको छ जे छ यही छ हाम्रो सानो कोट छ कम्ती केसहरु छ थुप्रो केसहरु पनि छैन ठुलठुलो केसहरु पनि छैन पैसा थुप्रो कमाउने बाटो पनि देख्दिन हाम्रो स्टेटै सानो छ पपुलेसन पनि कम्ती छ तर सत्य त चाहियो नि त जस्टिस त चाहियो नि त हाम्रो मान्छेहरुलाई हैन all of you have come from different walks of life isn't it all of you have seen difficult times good times sad times terrible times and excellent times this is what life is all about should we give up then एउटै केस त छ भोलि पनि गरिहाल्छु नि पर्सि पढेर भइहाल्छ एकछिन अगाडि पढ्यो भने त भइहाल्छ नि त हैन कसै गर्ने तपाईहरुले सोच्नुपर्छ मैले यो लेक्चर दिएर अल्टी दिएर ठुलठुलो कुरा गरेर चेन्ज हुँदैन we can't bring about change in our society until you decide to change it. And I'm telling you, giving you an assurance, if all of you work hard, understand how this process is, churn the truth the way it should, believe you me, one day your state will be proud of you. It is bound to happen. But we must work hard. Each of us must work hard. तपाईको जहाँ जहाँ लिएर आउनु भएको छ सत्यको खोज लेखिदिनुस् र घरिघरि पढ्नुस् त्यो सत्यको खोज तीनटा वर्ड त छ हैन अहंकार नराखी इगो नराखी है मैले यति ज्ञानी छु म त फर्स्ट क्लास फर्स्ट आएको म त टपर हो म त एमए गरेको त्यो सबै अहंकारहरु साइडमा राख्नु तपाईहरु all of you have succeeded in various walks of life Some of you have been excellent speakers, some of you have been excellent sports persons, some of you have been excellent in academics, some of you have done well for yourself in different arts. I'm sure you've achieved the way you've achieved in your school life and in your college life. I'm sure you're all proud of it. But there is a greater cause to serve now. Give yourself to that cause. If you do that, believe you me, everything will fall in place. Suddenly, if you read the Evidence Act, अङ्ग्रेजीमा त लेखेको छ नि, होइन? छर्लङ्ग हुन्छ, क्लियर हुन्छ, त्यो प्यासन हुनुपर्छ, त्यो पागलपन पनि हुनुपर्छ, त्यो पागलपन सत्यको खोजलाई. Documentary evidence, oral evidence, expert evidence are all there strewn in different sections of the IPC, the CRPC. Now take for example POCSO Act. It's a special jurisdiction. Many of you are now dealing with POCSO cases. As a lawyer, it troubled me to do POCSO cases. As a judge, I have no choice but to write judgments. And when I read the POCSO Act, I'll give you another example. Again, long time ago. I talk about history now. I'm almost part of history. Long time ago, when I was in Delhi, I was asked to brief a very senior advocate from Bombay. It was a matter relating to Sikh industries. So we had what you call statute called Sikka, Sikh Industrial whatever Act, and I went to brief. He's a legend by the name of Mr. Iqbal Chatla. I went to brief him in one of the 5-star hotels where he was staying. I went with the brief. I sat down with him. Every senior advocate has a different style of functioning. He told me, Bhaskar, when is the matter? I said, tomorrow, he asked me. Then he asked me, actually disclosed, this is the first time I'm doing a matter under this act. I was taken a little aback. I was a little worried. And then he said, let's keep the brief aside. Let us read the bare act. So we sat down and we read through the bare act, one by one, every section. Over that time, we discussed a few things which he was doubtful about. With the little bit of experience that I had in this jurisdiction, I explained to him. Then he, after 2 hours, said, let's stop here. I need to rest. Let's meet again tomorrow morning. And then we met the next morning. And then he asked me to tell him the facts and brief him about the case. So I did. He wrote his list of dates. Believe you me, one thing common among all these legal luminaries is the list of dates. If you were to see the interviews of Mr. Fali Nariman, and you will see it on YouTube, he will also say list of dates. And I must admit, I learnt it from these luminaries, this thing of list of dates. And therefore I keep fervently pleading before all of you to do it well. It's not coming from me. I'm a small fry. These legends have told me. And I think it is important for me to share with all of you that you become legends one day. What I could not become, I'm sure you will become. So Mr. Iqbal Chatla next day came and told me and asked me to brief him. I did. And then by the time we finished, it was 9:30, we went for breakfast. 11 o'clock was the case. We went there and then he started pleading before the court. He took out the bare act and he started discussing the bare act with 5 of the members of that tribunal who have been doing only Sika cases for donkey's years. And when he started talking about the act, I didn't know how to react. It was as if he knew the act for years and years. He not only read the act, he explained the nuances of the act, how it is supposed to operate, and explained every little detail. And then he placed the facts. And when he placed the facts, every member of that tribunal knew exactly how the impugn order had gone horribly wrong. They stated immediately. He came out of the courtroom, he thanked me for teaching him the law, and went away to Bombay. There's so much of learning from that. But what you need to take away from that is learn the law. Understand it, appreciate it, and see how it operates. What we do, and the common mistake we do, is the case relates to the POCSO Act. He is accused of Section 5, Section 7. So we read that provision, and that's the end of it. But believe you me now, when you go back and next time a POCSO case comes to you, take a glance of the entire act. Read it. In the beginning, it will tell you why this act was brought into place. Understand why it was brought into place. See how the act operates. There are 2 very important sections, 29 and 30. It talks about reverse burden. Keep that in mind. The act is applicable to cases in which the victim is a child. It is so important then that the prosecution needs to prove that the victim is a child. Again, in this thing of age and child, every case that comes before the High Court is relating to the age of the child. And then the first question we ask from the court is, what was the alleged age of the child? And the answer comes from the learned appellant's lawyer, 8 years old, 9 years old. And I think to myself, when the trial court is facing a criminal trial and conducting a criminal trial, the victim is before the court. The victim is not only before the court, but it is before the prosecutor as well as the defense. They all get to see this child. Can't you make out the difference between a child and an adult? You can, can't you? By one look. Isn't it? But when the matter comes in appeal before the appellate court, when the defense challenges the order of the trial court and says the only question that is open and which I am worried about and I am challenging is the age of the 8-year child has not been proved. Something horribly wrong has gone in the trial. And this is happening in every POCSO case. Somewhere we are going wrong then in the trial. Why is the age of our 8-year-old not proved? And then there are cases where the girl child is now 16 years or 17 years. I've seen 17 years and 11 months. And again, the defense is asking, questioning that actually she's an adult and the age has not been proved. And then I'm asking to myself, when I see a young girl of that particular age, I can't be sure. When I look at you and I look at you, I'm unsure whether you're 17 or 18 or 20 or 21. You look 17 to me. I don't see you are a day older than 17 from the look on her face. That's how I see it. It can happen, that is a fact, isn't it? So when you see as a defense lawyer a young girl who may be a woman, aren't you curious to know whether she is a child or she is not a child? Wouldn't that be a good defense if she was an adult? Actually, wouldn't it be wise for you to find out, do a little research and find out? Today is a world of internet, Facebook. There's so much of information out there. If you were to now know that the girl victim was actually not a child and was an adult, your perspective of the case would be different. It would definitely not be a case under the POCSO Act. It may be a case under another act, but it may not be a case under the POCSO Act. But aren't you curious? Because I don't see that question coming in. There are no question asked. The third thing I want to highlight in this art of cross-examination and examination and the role of the defense, somehow, somewhere you've been told that you need to deny. So there is a denial. So prosecution lays down their story and all of that is reading against you, and now your role is denial. Because the witness is not going to budge, you know also. From the body language, you are quite sure that that person is not going to answer your question. But somebody has told you, deny. So, number one, I did this. It is not a fact that I did this. It is not a fact I did this. It is not a fact I did this. It is not a fact I did this. And 3 pages of it is not a fact that I did that and I did that. What is the outcome of this denial when it ends there? Have you thought of it? What is the outcome? And what is, you have denied it, but what is the witness? Witness is relevant, not you. What has the witness done? Told you that you are lying and I am speaking the truth. Right throughout. It is not a fact, it is not a fact, it is not a fact. Then what happens? So, truth resurrected by another set of truths. By your denials. So, it is important to do your denials, but it's equally important to bring out your story. At least, when there is a denial, let us take a case of a girl who is 17 years and 11 months. And therefore not an adult and therefore a child, as claimed by the prosecution. You have denied the age, you have denied the birth certificate, you've done all your denials. But the one crucial question, what would that be? Looking at your appearance, it is quite clear that you are an adult. So somewhere on the records, the court realizes that from physical appearance, the child may not be a child. And therefore now, when you put that question, the relevance of that denial becomes that much more important. Suddenly the judge is questioning this birth certificate. Is it a photocopy? Oh, the original has not been produced. Oh my God, it has not been approved by the maker of this document. The registrar of births and deaths have not come to the witness box. Now all this becomes relevant. There is a question mark on the evidence led by the prosecution. Have you run away from the truth? No. What you've done is created a doubt, and rightfully so. Legally correct. What is visible is what you see. You brought that to the notice of the court. Now the court is to search. And when they don't get that answer, doesn't it help you? But this is something which you see, don't you? The victim is right in front of you. नर्मल कुरा गर्दाखेरि त तपाईहरु जाँदाखेरि घुम्नु जानुभयो है, डिनर जानुभयो, कता जानुभयो, एउटा त्यहाँनिर केटा देख्यो, एउटा केटी देख्यो, तपाईहरु यसो हेरे ए यो त हामीभन्दा ठुलो जस्तो लाग्छ भन्ने क्वेशन त हुन्छ नि, कुरा त हुन्छ नि हैन, मभन्दा त 1-2 वर्ष ठुलो होला भन्ने त्यस्तो थट्सहरु त आउँछ नि हैन। यो क्युरियोसिटी रेस्टुरेन्टमा हुन्छ भने कोर्टरुममा किन हुँदैन? तपाईहरु साथीभाइहरु घुम्नु जाँदाखेरि है, गफहरु गर्दाखेरि एउटा केटीले केटी देख्दा, केटाले केटी देख्दा, केटाले केटी देख्दा, केटीले केटा देख्दाखेरि यस्तो कुराहरु त भइरहन्छ हैन। त्यो क्युरियोसिटी कोर्टरुममा किन हुँदैन? सत्य खोज्नु पर्यन्त अन्त पाइन्छ। क्युरियसै हुनु भएन भने त्यो सत्य नै पाउनुहुन्न। अब why are the courts making such a fuss about age proof, birth certificate? The question which you asked, what was that question? Let's try to answer that. Contents of the document. What is the relevance of contents of the document? You have a blank piece of paper. You have? Write a letter to the judge. Address it a letter, just write a letter. Address it to the learned, what? Learned who, judge? What are you writing? I didn't tell you what to write. You're writing a whole story. You wrote the address. Okay. Now write something terrible about me. Write something terrible about me. Don't say I'm a kind person or a nice person. Terrible about me. You wrote? Now, he's the judge, right? And you're the lawyer. You need to give that as evidence. What do you do? She's the lawyer, you are the witness. You wrote that terrible thing about me. What do you do? Take the document. You will file it in court. Okay. So you will file it in court. He's the judge, right? You filed it. Now you have to prove this document. So what will you do now? Okay. So how will you examine? What is the question that you will ask? You will show the document to her and then... Okay. And if she answers all in the positive, And what is recorded? Yes, it is my document, I have written it, I have signed it, and I have written the contents thereof. Right? Now, what has been proved? Sorry? Right. But can you read out what was written about me? Loudly. Take a mic. Give a mic to her.
Justice Bhaskar is terrible.
Nasty lawyer. Has that been proved? Has that been proved? Do I become nasty because she says I'm nasty? So how is this contents proved? How is this contents to be proved? That's her opinion. It has been proved that she wrote it, that she does have an opinion about me that I am a terrible person. But am I really a terrible person? Each of you go back home and think about it. Yes. Sit down, sit down, sit down. Ah.
There's a circular by our Hon'ble government when Lordship stated when he took personal charge. So there were a lot of instances where 164 to be approved, they were calling the learned magistrate and asking them that they do it. So there was a circular issued by the Hon'ble High Court saying that since 164 is a public document and there are 2-3 judgments of Andhra Pradesh High Court, there is no need to call the learned magistrate to prove those documents. 164 being a public document should be taken as is. So the same question is that even 164 is a public document and there are other public documents. Shouldn't then the presumption already come that the contents are proved, or do we actually have to every time call even for a public document? Because then again it goes to probative value. How do we determine what is the probative value once a document?
It's a very important question, isn't it? So when a person, a doctor, a medical doctor, he conducts a post-mortem, he prepares a post-mortem report. He writes down what he sees and that is produced in court. Right? That is what is called the best evidence. In certain cases, in cases of experts, right, the law itself provides that when a document is produced, certain things are to be presumed. But when you are questioning beyond these things, let us take for example, you're questioning that the 164 record reflects that the judge recorded this document on the 1st of January 2023. But according to the calendar, 1st of January 2023 was a holiday and therefore the judge could not have been present. If that is your question, then it would be relevant for you to ask the court for a direction to cross-examine the witness in their presence. But sometimes, because of the law operating in a particular manner, the law itself provides that, yes, accept these things, expert opinions for once. The law itself provides that, accept it. But when it is questioned, the veracity, the truth, the correctness is questioned, then the witness needs to be produced. They are like ordinary witnesses then. Yeah? So it depends on, you see, when you look at Sikkim, you don't see the perspective at all. But think of UP. Then you will understand the perspective. Think of Andhra Pradesh. If the medical doctors and judges were to run from one court to the other because he has conducted 200 post-mortem in a day, then he will stop functioning as a doctor and he will be a witness in the courtroom, and somebody will have to provide a room permanently in the court complex so that he deposes, because every judge is going to be angry that the witness didn't come to his or her court on time. So in these complexities, some certain leeways are given. So you have to keep that in mind. But it depends on you how you want to question it, how you want to. If you have these line of questioning, then you can definitely request the court, and the court must give you that opportunity because they are witnesses, right? They're not coming as judges. They're not coming as doctors, specialists, even for handwriting experts. Very interesting thing I learned, and I think we will end it. I need to do other things in court, so I'm sorry I have to end it here. But a very interesting thought I will give. We talk about expert opinions and handwriting experts, isn't it? Now, when you talk about handwriting experts, what happens in the courtroom? There is a document which is alleged to be forged, and you look at that document, you think it is a forged document, you request that this is examined forensically, right? And it is to be sent for forensic examination to an expert. That's a request made. So what does the court do? The court then takes the disputed document, right? And then takes the admitted document, which is supposed to be in the handwriting admitted by the person who is supposed to have forged this document, and sends it to the expert. And the opinion of the expert is asked. This is an admitted document. This is alleged to be his document. Can you tell me it is forged? Now think about it. If somebody were to ask you that question about a signature coming in the forgery, wouldn't you know? You also can see. So why do you need an expert? When you are leading the question to the expert, this is the forged document, this is the admitted handwriting, this is the forged handwriting, tell me whether this is true or not. You've given all the answers to the expert. So what is his expertise there? Do you think an expert opinion has come when he says, yes, it is? Think about it. It happens all the time in the courtroom, doesn't it? We do it all the time. You are really feeding the answer. If, as lawyers and criminal lawyers, when you see a forged signature, don't you see it? You can see it, isn't it? He is the forged guy. So expert opinion is. Why are we even sending it to the expert opinion? Because the judges themselves have the power to compare under the law. The opinion is only a guide to the judge. The judge has to render the judgment and say it is a forged document. So why are we even sending it to the expert? Now how I learned this story, the last story, before I go. I went to brief Mr. Ram Jethmalani in a case. Again, as the worried lawyer that I was, always excited and nervous, I studied the brief. It was a case of forgery. I studied every Supreme Court judgment on that, made a compilation, indexed it, flagged it, paginated it, and then went to, at that time I was a senior advocate, mind you. But then I was going to a legend, and I was nervous like hell. So I went to him, and then I gave him the compilation. He looked at it. He smiled at me with that glee. And then I talked about forgery, and I told him this Supreme Court judgment, that Mr. Sanghi would do that when he would brief me. And then In the end of my rattlings, he said, Bhaskar, wo kone mein jao, just take out that book. It's third from the left. So I went and took it out. He says, turn to page 128. It was Tagore Law Lectures. And I took it out and he said, read from there, this particular page. And then I read it. And it said, that time, Tagore Law Lectures was, rendered years ago. The question that was asked is, if you are going and leading all the questions about fingerprint to the fingerprint expert, what is the expertise that you are seeking? This was done said by a very illustrious criminal thinker. The better thing to do would be to send a mix of documents with various signatures and ask the expert to find out which is the forged one. If he pinpointed the forged document as the forged document, you would be sure that it is a forged document. Why am I telling you this? None of you are judges. I want you all to think. Sometimes thinking out of the box may help your client that much more. Be innovative in your thoughts. Don't be extravagant. Don't go overboard, but think out of the box. Sometimes you will find extraordinary things in the ordinary. Thank you so much. Thank you so much.
Our query is, do these provisions need a very strict construction and interpretation, or does it require liberal interpretation?
What is strict construction? What interpretation of what?
For example, certified copy of public documents.
You're reading 76 or?
Yes.
Huh.
76. So basically it says that the officer should, together with a certificate written at the foot of such copy, that it is a true copy of such document or part thereof as the case may be, and such certificate shall be dated as such. My point is, Lordship, when an officer usually sits in a office and then issues those certified copies, many of them are not very well versed with the law.
Correct.
So sometimes they put their signature, write their designation, they do check the documents, but they unknowingly add the word attested. Does it mean that you literally strictly instructed to be written so that proof for that evidence to be admitted?
I'm glad somebody is questioning because I questioned it
Yes, sir.
when I was a lawyer.
The process is more important, I think.
But according to me, it's wrong. Way back in England, in this matter called Taylor versus Taylor, followed by Nazir Ahmed, a well-settled law was laid down, and that is, if the law requires you to do a certain thing in a certain way, it must be done in that way and in no other. Taylor versus Taylor, later on Nazir Ahmed, and followed consistently by our Supreme Court and various high courts. Follow that. In 164, if you follow the mandate of the law and require and give all the protection which is needed and which is the guidance of the statute, then the recording of the 164 statement of the accused is an assurance to the court that what he did was the truth, that he really wanted to speak the truth, and he did. But when you do not follow these statutory compliances and then leave it to the vagaries of the defense lawyer and the prosecution lawyer arguing against themselves, the court is a confused court. Never will the court believe that. So keep this in mind when these compliances have to be done. Strict compliance is very, very important, because then, see, ultimately what is the goal? You got to understand, why are you certifying this particular document? It is for a purpose. It is a public document, isn't it? So if you understand the implication of these documents and what the weightage it has, moment it is a public document, it takes within its fold certain assurances. The court presumes a lot of things. It is not to be proved in the manner ordinary documents are. It is like layperson and the elite. If you compare that, then a public document is an elite document. You get all the advantages which the ordinary documents does not get. Now to take that advantage, you must have that protection as well, isn't it? Now, if you just really don't, if you talk to me in the abstract, it will be very difficult for me to. If you give me situations which you will not give because you deal with cases which are live, I keep that thought to myself and end the day. Thank you so much. God bless all of you.